rise. The Court of Appeals Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is time set for oral argument in our case number CV220658. Now, counsel, you're going to have to help me on some pronunciations when we get to that point. But Gyau versus Total Transit, I'll start with that, and I'll hear a better response later. How about that?
Thank you, Your Honor. Good morning. Happy Valentine's Day, everybody.
Well, and to you as well, and to you as well. Each side is allocated 20 minutes for oral argument. Appellant, you can reserve a portion of your time for rebuttal if you wish to do so. If you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel, I would remind everyone in attendance to check and make sure that your phones are off. That also will avoid embarrassment. Our proceedings are being recorded, and they'll be posted to YouTube in due course, so please, as you begin your presentation, tell us your name, the party that you represent, and particularly with the appellant, how to fairly and accurately pronounce the name of your client. So with that, Mr. Cohen, you may proceed.
Good morning, members of the judicial panel. My name is Larry Cohen. My client's name is Gyau. So you were close. Thank you for hearing us this morning. The issue before the court is not whether Total Transit owes UIM coverage to Gyau for injuries he sustained. The real question is, with everything we have here, how could there not be coverage? We have a situation where Total Transit literally told everyone that we are an insurer. We have coverage. We have coverage for UIM claims. We pay them up to $300,000. And we do it out of an SIR of $500,000. They told the state of Arizona that through a certificate of insurance. They told their other taxi drivers that by paying UIM claims from the SIR during the same time period we're talking about here. They told Gyau literally there is coverage, and they stood by that for over 3 years that there is coverage. And after they told them there was coverage, they paid another taxi driver, and in the way in which they paid them, the document, they referred to themselves as an insured, as an insurer. They referred to him as an insured. They referred to a UIM policy, and they said they were resolving the case with him that he was making as a UIM claim.
Counsel, let me ask you, this is, to me, an unusual case because of the self-insured retention aspect of it, among other things. But help me, I don't view self-insured retention amounts as insurance. But I want to make sure I understand your position in this case as to whether the SIR is insurance or if it's something else that you're referring to for the contract of insurance.
Well, the SIR, Your Honor, is a fund of money out of which this particular company chose to handle its UIM claims. We know that they were handled out of that because in the certificate of insurance, which I know all of you have, it's a centerpiece. If anybody doesn't have it, turns out I brought an extra copy. But it is a document out of which we know that because it says they have a $500,000 SIR and they only pay $300,000 for UIM, so it comes out of that. We know they have a process through which they handle these claims out of SIR. We don't know about the process. We know that they had policies and procedures. When asked for them so we could see what these were and how they related to the SIR, they said, we don't have them. So I was talking to the person who runs the company for purposes of risk and insurance, has been running it for years. And I said, okay, you don't have them? Fine. Tell me about them. I don't remember them. I don't remember anything about any of them. So our ability to find out exactly how this payment process worked, how this processing of claims worked, was not available to us.
Before we move on, I want to get back to Judge Thomas' question. Do you consider the retention to be insurance, regulated as such, or is it something entirely different?
Well, Arizona has not addressed that issue. Other states have, and they're mixed. Some say it's not. Several cases that we've cited in our brief say that it is insurance. In my view, Your Honor, it is part of the policy program, the insurance program that they have. It's the fund out of which they take the money. So I'm not here to argue that an SIR is insurance, although, again, that argument can be made based on precedent in other jurisdictions that we've cited, Michigan, Massachusetts, and I think New Jersey. All are places that recognize SIR as being insurance. But our point here is that the SIR is part of this program that they created through which they pay claims and through which they provided coverage for exactly what we're looking at here. Now, they told the state of Arizona in telling them that they were an insurer, that's in the certificate of insurance, in telling that there was a policy, they refer to policy terms under the SIR, so they refer to the SIR in terms of something that has policy terms and conditions. So there's an argument to be made that it is in fact part of the policy because they use that language in the certificate. Now, the defense made an issue about whether we were saying the certificate creates insurance. We're not making that argument. We're making the argument that identifies the fact that there is policy coverage for this process of UIM claims. So the answer to Your Honor is I could make the argument, but I know Arizona hasn't adopted it. I think there's an argument to be made, but our position is that it's part of the fund-paying process of coverage for UIM claims through which these are taken care of.
What is the contract of insurance in this case? Where would I find that?
Well, the contract, Your Honor, again, that's a problem for us. They would have it, and when we asked about it, they said, well, we don't have it. Just like we asked for their policies and procedures, which presumably would describe what that contract is, because according to the claim representative, Mr. Wachowski, as well as according to Ms. Tyree,
right,
they operated this way. So the policy would be described there. But our argument is...
Well, and I guess what I'm asking is, what is the contract? Because I get the policies aren't available, and that's an issue that's been briefed. I get the statements made by representatives, but I guess for a breach of contract case, I'm very interested in the contract, and I'm not quite sure what it is in this case.
Well, I can't show you a document because they had it and they said it didn't exist to give to us. So in our complaint, in our First Amendment complaint, in paragraph 28 under breach of contract, we laid out what we knew at that time were the bases for the contractual claim. Now,
and as I read that, I see you pointing to the coverage that was established by the Certificate of Liability Insurance, and then there's some confirmations that follow. That suggests to me that you were relying on the Certificate of Liability Insurance as the contract of insurance.
We're relying on it as evidence of the existence of the contract of insurance, Your Honor, because, again, I could argue from other states that this becomes a contract the way that they reported it to the state. But I'm concerned that since Arizona hasn't adopted that view before, that this court might not be comfortable with that. So I put cases in the brief through which the court could go that way. But
I understand that, but I guess we're pretty deep into this case, and it's a breach of contract case, and I'm intrigued by knowing what the contract is.
Well,
and I'm unclear on that, and that's why I wanted us to talk about that.
So I've tried to talk about that in the context of what we know. There certainly was a contract, in my view, created when we went to Ms. Tyree and said, you have coverage for our client.
So it was 2 years, sort of, that happened about 2 years after the accident, is that right?
Yes, Your Honor.
So that's when the contract was created?
In my view, Your Honor, and I've tried to explain why, and I appreciate Your Honor's not satisfied with my answer, but I've tried to explain why, based on the Certificate of Liability Insurance, there is a policy, and so there is a contract described in or through the Certificate of Insurance and developed through the evidence. There is the agreement, which I believe is contractual in nature, that it was created when Ms. Tyree responded to our saying, you have insurance, and if you tell it, we have coverage, and if you don't, then we're going to go and sue you. And she said, we have coverage. So we said, okay, we won't sue you. So offer acceptance consideration.
So it happened, was that 2017?
It was February 2nd, 2017.
And for an accident that occurred 2 years earlier?
and it relates back to the accident that occurred 2 years earlier. So
So let me clarify, are you saying that's when the contract was created, or are you saying that she confirmed a contract? I need to understand that better.
in my view, she confirmed the existence of, that there was a policy of insurance that applied. That's what I think that she did. But I think she also created a separate contract by agreeing that there was coverage and that it would be paid. The direction was to turn in the evidence of damages and pay it. So I believe that the certificate of insurance shows that there's a contract that there's a policy and coverage, and refers to a policy in its language, that she reaffirmed that when she said that they would pay the claim, the UIM claims, pursuant to what was in the certificate of liability insurance, because when you looked at the letter, you saw that I referred to that. I believe that the acts of paying for UIM claims consistent with the certificate is evidence that there is a contract and there was insurance prior to our accident, because they were paying them back in 2015. And I believe that the language in the release that we were able to obtain of the individual who settled after she made the promise to my client has language in it which says that there's a policy of insurance. So all of that points to a contract.
What were the terms, then, of that contract?
The terms of the contract, in terms of their conduct, in terms of what they said they would do, is that if an individual suffers, and again, looking at the information we have at the certificate of insurance, is that if you suffer an injury that is in excess, that has damages in excess of the underlying insurance, the person who injured you, that we will pay up to $300,000 under UIM insurance out of the SIR that we have.
With no reasonableness screen or, requirements? I mean, what if, and I'm not saying this happened, but what if instead of seeking medical attention, there was a thought that spending time on a tropical island to the tune of $250,000 would be a good thing? Would Total Transit be on the hook under the terms of the contract for that?
Well, I mean,
I know that did not happen, and I'm not suggesting.
Sorry, Your Honor. It could well have happened. My client's from Africa. Maybe he would have gone home and hung out there.
No, and I don't mean to, I use that hypothetical to try to better understand it, not to trivialize the injury that your client sustained.
Not at all, Your Honor. Again, I'm not trivializing either. Maybe he would have gone there to get medical services, and we would have had an issue about whether they were valid medical services. So I recognize that. But the problem that we have is that they did have ways of addressing that. They did lay that out somewhere. Where did they lay it out? If nowhere else in their operating procedures, their standard operating procedures for implementing this program. The problem is that they said that they didn't deny that they had them. They said, oh, we can't find them. And they didn't say they didn't address the issue. They said, we just can't remember anything that they said. So our case is based on the fact that all of this information is out there from which a trier of fact could then draw a conclusion about the nature, substance, and extent of the agreement that they made to provide this coverage. We know it through their acts, we know it through what they said, but do I have a document? No, because they control the document and they didn't give it to us, or anything else that related to it, even though we know it all exists.
Counsel, it seems the record is devoid of anything other than we told everyone we cover everything, but about your client's expectation about coverage before the accident happened. Was there any documentation provided to him? Was there any kind of employee manual? I know it was an independent contractor relationship, but was there any kind of delineation about what would be provided by the company that your client was relying on?
If you're asking, Your Honor, for a written documentation, the answer is no. We don't have any evidence of that. What we do know is that the certificate, of which he was not aware, I will readily admit he was not aware of the certificate before this happened. We do know the certificate said it covered any auto, and he was driving a leased auto. So the insurance policy applied to that car accident, and then the issue is what UIM benefits would he get, which is the issue that Judge Stuma and Judge Brown were just exploring with me. And so we know from the certificate it covered the auto he was driving because it was their leased auto.
Was there any information in the glove box of the car, or inside the vehicle?
I had nothing to offer the court by way of documentation that was given to him. He was driving a vehicle in Arizona. He did not know about the certificate of insurance. They did not give him information to know about it. So when it came time to make a claim, he started looking for what exists, which is not, respectfully, even the tiniest bit uncommon in how 99% of the population operates with insurance.
What do we know about the independent contractor relationship? I believe I read that he did sign some type of independent contractor agreement. Am I wrong on that?
No,
Or do
you're
we
not
have a
wrong.
copy? Do we have a copy of that? No.
He did not maintain it, and it was not disclosed as part of what happened here. It's something that presumably if they had, they would have disclosed, because 26.1 would have required it.
Well, and likewise, if your client had it.
If my client had it, he would have, but my client did not have a copy of it. My client's not a sophisticated business person, he's a taxi cab driver.
So,
But looking back, should he have asked about the insurance? Sure, he should have. I respectfully would suggest that it happens in the general population about 0.1% of the time, but it probably does happen, occasionally.
So there was a contractual relationship between Total Transit and your client. It was an independent contractor relationship defined by we don't know what terms. Is that accurate?
It was defined by, you lease a cab from us, you go out and drive the cab, you pay us a portion of the money that you get, you can keep some of the rest, come back tomorrow night and do some more. That was the extent of his understanding of the relationship. I need a job, they have cabs to drive, I can drive the cab and pay them money. That was the extent of it. And again, the issue of the extent of the insurance that might be available, like, again, I suspect almost the entire population, until an accident happens, you don't go and read the policy. You have an accident, you go read the policy, or go to your company and say, hey, I have coverage. What happened? So in this case, he goes to Total Transit and said, I'm driving your lease car. My liability, the liability aspect did not produce enough money, so I would like to make a claim to you for more. And they responded by saying, okay, you've got coverage. Submit your damages. We're going to pay you. I have 4 minutes left. I'd like to reserve the rest of the time if I could, please.
Very well. Thank you, counsel. We have two attorneys for Total Transit. I don't know who's going to be presenting today, but I'll look to you two to... Very well. You may proceed. And counsel, I will defer to you on pronouncing your last name, as I have with opposing counsel on his client's name.
Understandable, and I don't blame you.
With a name like Thama, I can appreciate that.
My name is Nikos Povilaitis, appearing on behalf of Total Transit. So the issue today is whether a contract for underinsured motorist benefit or motorist coverage, which I'll refer to as UIM, can be created without an offer, acceptance, or consideration, and based on waiver and estoppel. The elements of contract formation are not present. Total Transit never offered UIM to Guy never accepted UIM benefits, and there was no consideration paid for the UIM benefits.
Can I ask you, there are two pieces of evidence that I find curious that your client couldn't produce. One is the policy governing the self-employment retention fund and paying out of it, and the other is the initial independent contractor agreement with the driver. Does your client not retain records? I understand it was sold, but those seem like kind of intricate pieces of evidence.
As you said, the company was sold, I believe, in 2019, so records from that date aren't available. We do have a copy of the insurance policy with Scottsdale Indemnity, which discusses the SIR within the policy itself, but I believe that everything else was lost when it was sold.
So does Scottsdale Indemnity have the kind of underlying how this SIR is going to be utilized up until that excess coverage kicks in? Do they have that policy?
There's a policy in place for the SIR which discusses, that $500,000 initially is what's Total Transit has to pay before that excess liability policy with Scottsdale Indemnity kicks in. With regards to how the SIR is managed through Total Transit, I don't believe that Scottsdale Indemnity would have.
You don't believe, or you've checked?
From my understanding of the record and what I've seen so far, I don't believe they would have it.
So counsel, just so I understand, so since 2019 to the present, there are no policies and procedures for the handling of the SIR?
That's available to Julie Tyree, no.
She just makes those based on what? She makes a decision based on her knowledge and expertise?
Well, I believe that there was prior policies and procedures, it's just that they no longer have them anymore.
And there's no longer any claims that she handles for the SIR?
I don't believe she's employed with Total Transit anymore.
Can I ask counsel a couple of related but slightly different questions? And I get that this is not a corporate successor case, but was the transaction in 2019, was that a sale of the company or a sale of assets and liabilities? Do you know?
To that answer, I'm not sure, Your Honor.
That's fair, and that's not the focus of what we have. But and to follow up on Judge Brown's question, let me ask you to assume that the certificate of liability insurance that was in place for Total Transit with the Department of Transportation at the time of the accident here remains in place. That still talks about SIR and UIM. How does Total Transit know how, if that's the case, how does Total Transit administer that today? Not for claims in 2015, but if an accident happened yesterday. Do they have policies and procedures in place?
That answer, Your Honor, I'm not actually sure. I'm not sure I can answer that right now.
Okay.
So if I'll continue on, since we're on the topic of the certificate of insurance. Arizona law is clear that the certificate of insurance does not modify or create coverage. And we know that from Continental.
But Continental dealt with an actual insurance company, not a self-insured retention policy. So I go back to the question that Judge Thuma asked Mr. Cohen. Is a self-insured retention actually insurance?
No, it's not, Your Honor. It's just a basis for a company, a business, to maintain financial responsibility with the state of Arizona. That's what it's used for.
So how does Continental even apply in this circumstance? Continental was about an insurance company, a bad faith insurance claim, that kind of thing. This isn't an insurance company, this is a retention.
Incorrect. And so the specific point there is that the certificate of insurance was specifically for the excess liability policy Total Transit had with Scottsdale Indemnity. That was the applicability there.
True, but the certificate says this insurance policy with this insurance company does not kick in until we satisfy Total Transit our obligations under our retention policy. So we've got insurance, which is what the certificate says, but it also kind of delineates what the retention policy will cover, does it not?
Well, the retention policy recovers any of the financial responsibility requirements that's under $500,000, which is liability coverage and which was required at the time. That was the purpose of the SIR.
The certificate, though, also refers to UIM, right?
Correct. It does refer to UIM. And again, this was a certificate that was drafted by Scottsdale Indemnity. It was poorly drafted.
Well, and there's no mark out saying, no, we mean UM only. It's UM and UIM, right?
Correct. But what's only required in the state of Arizona for businesses was just...
Understand. By statute is UM, not UIM. But here, the certificate talks about UM.
It does. It's just generically bundled within it. So what's only required is, as we discussed, was UM and liability insurance coverage is required. There would be no reason for Total Transit to provide UIM coverage.
So what document did Total Transit provide to the drivers when they signed their independent contractor agreement, explaining what was covered, what was not covered?
Your Honor, Justice, I'm not sure.
You mentioned there'd be no reason to provide UIM. Why do you say that?
Because Total Transit doesn't receive a benefit for providing it. It's only an expense for it to provide UIM coverage. There would be...
What in the record would show that? I could envision a competitive benefit.
I'm not sure what the competitive benefit would be.
Come drive for us as opposed to the other guys because you get UIM here.
Well, the issue is that would be an expectation of possibly obtaining UIM coverage. Right? It's something that if it's offered, you're not even sure if it will be available at the time. because we're not sure of whether or not another driver on the road would have enough, if another driver on the road could have $1 million in
You
coverage.
would ease my mind. It would be better to drive, wouldn't you agree, with a policy that had for an employer with UIM coverage as opposed to one that did not have it? That's a slight benefit.
Well, I think it would be the same as saying that a company saying that we can offer workers' compensation through the SIR if you come work for us. Again, that's another situation where you're expecting something that may or may not come into effect, and I'm not sure of how much of a benefit that would be or really desirable for someone to drive for total transit.
It would be of some benefit, some quantifiable benefit, you would agree? Some. It's not worth arguing about. But, so, you've got this independent contractor agreement, you have this retention, you have this excess insurance policy. What governs the relationships between all of it?
It would have been the policy in place with Scottsdale Indemnity and Total Transit, and then how Total Transit would handle the SIR within their own business.
And that's not delineated anywhere in writing.
I'm sorry, for...
The relationships between all of the parties. I'm sure Scottsdale is not going to, let's say, according to Judge Thumma's hypothetical, you, in your retention, pay for his client to return to Africa. Scottsdale is not going to consider that in determining whether or not you'd met that excess amount. Would you agree?
I'm sorry, could you rephrase that? My apologies.
Whatever. Give it a shot, Sam.
Sure. SIR is 500, so you don't hit the insurance coverage until you hit SIR. If you pay for an around-the-world trip that costs $250,000 and you tell Scottsdale Indemnity Company, hey, we paid $250,000 plus $250,000 in health benefits, it's your turn now to pick up the full coverage. I sort of assume Scottsdale Indemnity isn't going to say, sure, that trip around the world was just fine. They're going to have policies and procedures about what it does and what does not fairly attribute to the SIR before you hit that $500,000 limit.
Correct, which in the policy itself, with the policy itself with Scottsdale Indemnity, in the SIR retention, they do discuss the terms and conditions for the SIR and what would be applicable and what coverages are expected to contribute to the SIR to the $500,000. So that is within the Scottsdale policy itself that does dictate some of the terms of how the SIR is handled.
Counsel, from the briefs and here today, we have been told, I think by both counsel, that there are factual gaps in this record that candidly I wouldn't necessarily anticipate, both with what happened for your client before 2019, what appellant may have received on intake with Total Transit whenever that happened. Historically, lack of facts cut one way or the other. What should we make of the fact that for your client, we're missing a bunch of stuff pre-2019 to determine how this either was or might have been administered?
Because I believe in Mr. Guy's deposition testimony, he states that there was never an insurance policy provided to him, and he understood it that there was not an insurance policy provided to him. And so I don't think necessarily that the gaps with what was provided in terms of documents provided to him are significant because of the fact that what he's trying to do now is create a retroactive contract for something that occurred and predated those letters.
And I understand your point on that, but let's focus then on your client and what Agent Tyree or person Tyree said for a period of at least a couple of years, suggesting there was money available for appellant, consistent with policies and procedures that we don't have.
Well, first and foremost, it was letters from Gyau itself.
Understand, and we're here on summary judgment, so I get exactly what you're saying, but they're part of the record, and we're not post-trial, and from your perspective, you never want to be post-trial, but what are we to make of that as we sit here today on whether there's a genuine issue of material fact?
Well, we know that Arizona law is clear that statements made by an insurance agent cannot create coverage where none existed before.
But we go back to, this is not insurance, this is an SIR, so how are we supposed to apply insurance, the body of insurance law, to a non-insurance product?
What Gyau is asking for is that the evidence shows that there is a certificate showing that there's an insurance policy. So while the SIR is not insurance policy itself, Gyau is trying to say that coverage should be provided with the funds through the SIR. And that would be, in effect, creating coverage where none existed before, because now we're paying out UIM benefits, which is an insurance coverage.
I think he's saying it's not only should be provided, it was provided in at least one instance, and it was confirmed provided by that would be provided by Ms. Tyree. I mean, I don't think he's saying that in and of itself, I think he clarified it's not the policy, but it's some evidence that there was I don't know if we're using the right terms here, because of policy, I don't know if an SIR it's not a policy. I don't think, from what I'm reading and what I'm hearing, it's not really a policy because we're not in the insurance world. It's some kind of fund. It's just a self-administered fund. And who controls the details and the terms and conditions of that fund? I think only one entity. It's Total Transit, correct?
Correct. And if I may discuss a little bit too, because I think when you talked about paying UIM benefits to other individuals, first and foremost, those settlement negotiations are precluded by Evidence Rule 408. They shouldn't even come in, because what Guy is trying to use is to say that he's disputing that Total Transit is liable to pay UIM coverage. Those are settlement negotiations to extinguish potential claims with other individuals. The terms used in there, insured or insurer, are used for matters of convenience only, and it's additional to whether it be UIM coverage or UM coverage, whatever it may be under. It's again a method for Total Transit to make sure that no additional claims can be made with the release or agreement. And I believe in the releases themselves, they state that this is not under any specific policy or anything specific itself. They never identified that we were providing UIM coverage based on X policy, whatever it was, because there was never a policy in place. There was never insurance in place for it. The only insurance that was available was through the SRL, was through the required UM and liability coverage. And so the settlement negotiations aren't evidence of whether or not UIM benefits have been paid in the past. There were occasions where Total Transit extinguished potential claims, and how they chose to do that.
Understood. Since we're arguably not in the insurance realm, can a oral contract provide the basis for liability for Total Transit? Just hypothetically.
Could you expand a little bit? I'm sorry.
No, I mean, does it have to be in writing? Does there have to be a written? Because it just seems like we're lacking written documents here. We're lacking written documentation in our record of what the self-SIR does, what its purpose is. I mean, we don't have anything other than what the parties are telling us through briefing. We don't have it. We don't have.
Counsel, you wish?
Yeah.
Yes, you may.
Thank you.
And please tell us your name as you present.
Can I stay here, or would you prefer me up front?
Microphone will be good, thank you.
The answer is an oral agreement.
And your name, I'm sorry.
I'm sorry, too. Michael E. Palumbo.
Please
I'm
proceed.
here for the defendants. The answer is no, an oral contract or an oral agreement is not able to create a contract, especially in the context what they're suggesting is 2 years after the fact, that, and this is in the brief, the oral agreement is for the purpose to prevent them from denying that there was an agreement to provide UIM financial responsibility. Now, what would have to happen is that agreement would have to say, this agreement will retroactively go back to before this accident occurred. We would have to have terms, conditions, agreements. We'd have to have offer acceptance in this, and that the person would need to know about that and alter their position for it.
Is that true?
After the fact, I'm sorry.
No, go ahead, please.
Justice. After the fact, you know, you're dealing with things that haven't been argued, whether it be the parole evidence rule involved here or something else. this is just simply a 2-year after-the-fact discussion of what may or may not exist, and the purpose would be to try to create something that didn't happen in financial responsibility beforehand.
Does that answer turn on whether whatever is here is SIR or insurance, or does it apply equally to both?
Well, and it's a nice question in the fact that I think we've established it isn't insurance, it's not governed by the Department of Insurance, and the SIR is a provision of allowing an entity that includes people in their vehicles for travel to make the financial responsibility created by statute. Now, the statute is very specific. So in this particular case, if the insuring agreement, if there was one to begin with, did not include UIM coverage, then no matter what oral agreement was involved, it could not then create a coverage that never existed before.
And I understand your point. I thought it might turn on, it strikes me that you can't agree to insure something that's already happened, a risk that's occurred, but you could agree to reimburse somebody for losses if you choose to, and I don't know that had happened in the past, and I don't know why that, and I'd like to better understand why that would have to be in writing as opposed to a verbal agreement.
So in this particular case, assuming that there was made a discussion of reimbursing us for expenses already incurred for health, okay? First, that doesn't exist in the record. But let's say
go hypothetical on that.
And it's a good hypothetical because if somebody had come to me under the SIR, even though there's no coverage, businesses constantly and regularly resolve matters before them. If somebody had come to Total Transit and said, which they have in other resolutions which have been linked, I want to resolve this case, and would you pay me or reimburse me for, that would be in the realm of something that could be negotiated. Would it be required? No. But could it be? Absolutely.
Okay. Thank you.
Okay. Do you need any, I know we only have like 35 seconds.
We do, and you have a cross appeal, and I don't know if you wish to be heard on that briefly.
It probably
either.
takes one more minute for that.
Let's do this. Let's give both sides 3 additional minutes, and you'll be able to address your cross appeal in that time, and you'll have a little more time, Mr. Cohen.
Thank you, Your Honor.
Very well.
Thank you, Justice.
So let's add 3. You may continue.
And let's wait till they get the
Yeah,
clock reset.
So that should be stopped. We're still with respondents' time. I'm throwing our good bailiffs a curve, so just bear with me. Very well. Thank you. You may proceed.
So the cross appeal is on whether attorney's fees should have been denied by the trial court judge. Total Transit believes that attorney fees should be available in this case. ARs by statute 12-341-01 or period 01 has 7 factors that it goes through to decide whether or not attorney fees are warranted. Total Transit believes that 2 factors are important. That is the particular merits of the claim presented by the unsuccessful party and the novelty of the legal question presented. Guy's claims from the outset lacked merit. He's based his complaint and lawsuit on a breach of contract. There was never a contract in place from the outset. There's no basis for his bad faith claims, which require, as a prerequisite, a contract in place to pursue a bad faith claim. Total Transit never offered Gyau UIM benefits, Gyau never accepted UIM, and Gyau never paid any consideration for UIM. From the outset, there was no breach of contract that could have been maintained.
Counsel, the Superior Court has not only discretion, but I think our court says substantial discretion in whether to award fees under 12-340-101, and if so, what that award would be. Do you agree?
Correct. Correct. I do agree that there's substantial discretion. I understand that that's the statute, but we believe based on the length of the litigation that's occurred and what the arguments have been presented by Guy, attorney fees are warranted. The idea that litigants should actively and diligently review their claim and the basis for their claim prior to initiating litigation and during litigation is paramount. They need to understand whether or not they have a successful action and whether they can take it, and whether they have merits to their claim and can bring litigation against a party. In this case, Guy did not do so. There's no case law that supports Guy's position that an individual who is not a first party to any sort of policy itself has a claim for underinsured motorist benefits in Arizona. We've seen case law from other jurisdictions, nothing from Arizona itself.
But the Superior Court acknowledged that, didn't he? In denying fees, said, hey, this is sort of a novel case.
The Superior Court judge did say that in Total Transit disagrees because the novelty of the case really is not present. The idea that someone can sue another individual and then pursue bad faith without an existing contract, with knowledge that there is no contract available, does not raise a complex or a novel issue presented to the court. And this has gone on through lengthy litigation. So, as the time of events, the accident happened in 2015, and then I believe in 2019, Guy submitted his complaint to the court. And here we are in 2024 still litigating this case for something over a non-existence of a contract. And so we believe that there is no novel issue involved. And based on the claims and what's been argued, there really is no merits to what Guy has argued.
Thank you, counsel. Time goes quickly. We appreciate it. Mr. Cohen.
Your Honor, I appreciate there's a question-and-answer process, but if I could just take 2 minutes to clean up some things that were missaid to you, I'd appreciate it. First, on the attorney's fees issue, the suggestion that this was a ridiculous thing that we were doing, 3 times they made exactly that argument to the court at the outset of the litigation. 3 times. 3 times they were rejected. And the court said, this is not a futile process, I'm going to let you go forward. So the suggestion that we were simply out there and without any rigging, any navigation or anything is simply wrong. So on the attorney's fees issue, I think that's what I'm going to respond to. If you have questions, I'll respond to other things. But I really want to talk about some of the other points that were made. It was suggested by both counsel that somehow this certificate of insurance that we're talking about is something that, there were mistakes and it was inappropriate and everything else. Julie Tyree testified, she looked at it, said there was absolutely nothing wrong. There were no mistakes. I went through it and asked her about the specific parts of it. You can see that in her deposition, which is in the record. This didn't simply float by, oh my gosh, what happened? She looked at it and approved it. She requested it, not of Scottsdale Insurance. She requested it of her insurance broker. Said, give me what I need to file. They filed it. She could have scribbled out UIM if she wanted to. She didn't. She could have scribbled out policy reference. She could have scribbled out that they were acting as an insured. She could have insured. She could have done all that, but she didn't. Next, and I very much hope you'll go back and look at my February 2nd letter, because they talk about it as if it's something very vague. It was very specific. First, during this telephone conversation, you confirmed that there is underinsured motorist coverage in the amount of $300,000 available for Mr. Gyau's claim from Total Transit, Inc., doing business as discount cab. Second, you will evaluate the elements of Mr. Gyau's claim toward the end of making an offer pursuant to the underinsured motorist coverage. I will confer with Mr. Gyau, and we also agreed not to file a lawsuit at this time. So again, 2 years after, yes. But let's look at what is 2 years after. They didn't talk about this either. Not only was there the certificate of insurance in place, but read Mr. Wachowski's deposition. He was paying UIM claims to cab drivers before and after Mr. Gyau's accident. He was paying it out of the SIR. He was paying it pursuant to all the standard operating procedures. They had an ongoing program. This didn't, my letter does not come out of nowhere. And in terms of these standard operating procedures that disappeared in 2019, read her testimony. They maintained a great deal of the company's records so they could finish up the company's business. One thing they somehow didn't have was the operating procedures. Where did those go? Okay, you ran this program for multiple years. Just tell me what the standard operating procedure said. I don't remember. Oh my gosh, I don't remember this entire program that I ran, paying out hundreds of thousands of dollars, and I don't remember anything about it. Okay, so that wasn't there. All right, well, they were there in 2017, and what did you do in 2017 knowing what your operating procedures were? You said there's coverage. You said submit your bills and I will pay you. This is not hypothetical. This is in the record, unequivocal. Mr. Wachowski said, I got my instructions from Julie Tyree about paying claims. They submitted claims, I sent them to her, and she made the decisions. This was not some hypothetical thing that only showed up when Mr. Gyau showed up. They had been doing this for years, exactly what Judge Campbell was asking about. They were paying out of the SIR, UIM claims. It appears that there's only one taxi driver whose claim they were denied. My client. They didn't produce a single piece of evidence of any other taxi driver who was denied coverage. We got one guy. And you have, and with regard to the settlement document, if you read the Murray versus Murray case, we are not offering that to show the negotiations. We're using that only to show the existence of a settlement, which under Murray is permitted. And if you then go in there and read it, it says, for purposes of what's being done here, the payment was being made under, quote, under any and or all portions of an insurance agreement of an automobile, including uninsured, underinsured motorists, medical payments, and other coverage that might be available, said policy issued to this guy. So you're saying, where's the policy? I'd like to know where the policy is too, because they refer to it in the certificate of liability insurance. They refer to it in the settlement document. There's a policy out there. They just chose not to give it to us. And a jury can then decide whether there really was a policy, because there are loads of issues of fact that you've heard about today. Loads of them, like, is there an insurance policy? They say no. They say it didn't exist, but they said otherwise in their documents. And we know there was a program. And we know there were operating procedures. And no, Scottsdale Insurance says nothing about it. You know what's in the record? What's in the record is me calling Scottsdale Insurance and saying, hey, do you have UIM coverage? And them saying, you got to go to Total Transit for your UIM coverage. That's in the record. So the suggestion that this thing is out there, doesn't exist, I'm sorry, this is just not an accurate depiction of what took place in this case going forward. And I'm sorry I can't give the court what Judge Campbell, Judge Thuma, and Judge Brown asked for with these documents. I went looking for them. I asked about them. They simply didn't produce them. And they're living off of that. They are living off of that in this case. Because by not giving them to me, guess what they get to say? They don't exist. Operating procedures don't exist. Policy doesn't exist, and yet they talk about it in their documents. So I think a jury may have a field day with this case, if Your Honors will send it back down, trying to sort out all of these issues. Now, I asked you to give me a chance to talk, and you did. You've got 13 seconds to ask me questions.
Counsel,
thank you for your time today.
Counsel, we appreciate your briefing. We appreciate your presentation today. You have given us much to think about. We'll take the matter under advisement. We will issue a written ruling in due course. We stand adjourned.